Hello everyone, my name is Manjit Singh and I'm a legal intern at LEXIS and Company. Uh, I'm a third year LLB student of Lord Law College. Today my topic is contempt of court. The term contempt of court, also known as contemptuous query, has been used for hundreds of years in old occasions. Ruler was viewed as the wellspring of equity and he used to hear the cases himself. With time, because of the expansion in the number of cases, the weight of the lord was moved to a different body made by the ruler, for example judges. The possibility of the hatred of the ruler was considered an offense and it was set down in the laws during that time. It was the introductions of the contempt of court, like how it arises and what were the consequences. Now the article 129 declares that the Supreme Court is a court of record and that it shall have all the powers of the court of record, including the ability to punish for its contempt. Article 142 clause 2 empowers the Supreme Court to investigate and punish for the contempt of itself, that is criminal contempt. The Contempt of Court Act 1971 does not define what contempt is. It simply explains the type of contempt. That is, there are two types of contempt. One is civil contempt and the second one is criminal contempt. Now let us move to the types of contempt of court. Contempt of Court Act 1971 classify contempt into two kinds. That we know that the first one is civil contempt and the second one is criminal contempt. Civil contempt, Section 2 subclause B. Civil contempt means willful disobedience of any judgment or a decree of a court or a willful breach of any undertaking given to a court. Determination of civil contempt is objective and is not based on subjective understanding of anyone. If there is a judicial order and if such order has been willfully disobeyed, then the fact of disobedience will constitute civil contempt. Now let us move to the criminal contempt, which is defined under the Section 2 subclause C. Criminal contempt as the publications of any matter which either scandalize or lower the authority of the court, or the such cases interferes or prejudice any judicial proceeding interference, or obstruct the administration of justice in any manner. Further, an act of publication will constitute a contempt if it even tends to scandalize the court authority or it tends to interference with any judicial proceedings or administration of justice. Now let us know what are the punishments for the contempt of court. Under the Section 12 of the Contempt of Court Act 1971, High Court and Supreme Court have vested the power in punishing for the contempt of court. A person who is held or found liable for such act will be punished with simple imprisonment for a term of 6 months or with the fine, which may extend to the 2000 rupees, or with both. Now, after discussing the introduction and definition and the types of contempt, we can conclude that the civil contempt is a necessary willful disobedient litigants who ignore the court order cannot be let off, otherwise it would be serious consequences. Thank you. Please like, subscribe and comment on my channel as well as on my video. If you have any questions with regards to this video or with regards to my previous video, feel free to comment on my comment box and ask your questions. Do comment your questions on the comment box if you have any questions with regards to my videos. Lastly, this video does not solicit any type of promotion or advertisement as per the guidelines of Bar Council of India, and the sole purpose of video is for the educational purpose only. Thank you.